SJC-12243, Virginia B. Smith and others, v. City of Westfield and others.
Mr. Kennefick, good morning.
Good morning, Mr. Chief Justice and Associate Justices. My name is Thomas Kennefick. I represent the appellant along with my co-counsel, Mary Patron. I think there's a motion that was presented and allowed by this court for me to share my time with my brother counsel from the Attorney General's office. So I guess I'll speak for 7 minutes and 44 seconds of sorts. Sorry. In preparing for this morning's hearing, I was struck by Justice Milkey's concurring opinion, particularly the last paragraph, where he states that the overriding point of Article 97 is to insulate dedicated parkland from short-term political pressures. I fear that the effect of Hansen and Mahajan is to rob Article 97 of its intended force with regard to a great deal of dedicated parkland across the Commonwealth. And he also states that he writes separately in the hope that the Supreme Judicial Court someday would revisit this precedent. And I'm very pleased that since upon our application for further appellate review, this day has come.
But let me be clear. As far as I can tell from your briefs, you're not saying the Mahajan is wrong. You're
No.
saying the appeals court misinterpreted it.
That's correct, Judge. That's correct. We're saying there's more than one way in which land can be dedicated to purposes that would be afforded Article 97 protection.
So, I was just going to ask you, I guess I'm trying to understand, following up on Justice Gantz's question, whether you're saying that the appeals court majority got it wrong or that it got it right, but that we need to change the law.
I'm saying that the appeals court, according to Justice Milkey, said that he's constrained to agree with the opinion in terms of Hansen and Mahajan. We're suggesting, though, that the reading of the Smith case as written is bad law in the sense that Hansen really ought to be, it's an outlier, it ought to be held to its own facts, and Mahajan, in terms of how it's reading, is that it affords more than one way for designation of land. Hansen, at least in the Smith case, as found by the appeals court, essentially basically establishes a recording rule if you're going to designate land subsequent to its acquisition.
In my mind, your biggest hurdle is Hansen, because Hansen, in some ways, parallels your case. We have a tax taking, we have municipal action, and then we don't have a deed that follows up. And what I'm trying to get you to ask you is, and you said Hansen's an outlier, and I know there was a third-party purchaser that was involved in Hansen that we don't have here. How do you distinguish Hansen, or are you telling us that we should decide that Hansen's no longer good law?
Well, I'm suggesting, Judge, that although you may consider Hansen still to be good law in terms of its own facts, namely that the actions taken by the town of Hansen, I guess it was, in terms of what it did, it never took a step beyond that town vote, and never committed it to even the Conservation Commission. And so dealing with a third-party bona fide purchaser for value, and even I guess in that case, there's a question whether that party was a bona fide purchaser. But putting that aside for the moment, you've got here in Westfield a 60-year history of acts that constitute clear But
in Mahajan, we rejected the use. We rejected use as a standard, the Attorney General's opinion. We rejected that in Mahajan, correct?
No, I think in Mahajan, you would look to the prior public use. And I think here with Mahajan, you can, by looking into the prior public use in terms of what Westfield's actions were with that playground, you would see, I think, certainly an act that would constitute dedication for purposes of Article 97. Unlike Hanson, for example, you had in 1946, there was a tax taking in 39. 46, there was a transfer from the planning board to the playgrounds. 48, they began to fund it. 57, there was an ordinance that basically dedicated that land for playground purposes. In 1979, you had LWCF funding, and which again, by taking state funds, there's essentially a covenant.
So what rule of law springs out of this case if we accept your proposition? Because obviously if there's a deed, there's certainty, and that's...
Certainly.
Right. But if we agree with you, now we have Hanson that says a town meeting vote was insufficient standing alone. And we have your case where we said what happened in 1946 through 1979, those 4 discrete acts that you just laid out are enough.
Mm-hmm.
Well, what's the rule of law? What guides cities and towns and Superior Court judges and Land Court judges?
Well, I think there are a couple of things at play here. One, I think the Attorney General in his brief suggests an analysis of the totality of the circumstances. I think that when you look at as I think oftentimes you must, when you can't see, many times you're not going to see the origin of public land. I mean, the Boston Commons, for example, the Lowell case discussed that. There are any number of other cases. And if you're just to use the recording rule, as it were, you could, I think, again, in some of the amicus briefs that were submitted, you could create municipal havoc. So I think when the situation arises where you have a circumstance such as this, where you're looking to determine whether there is a sufficient dedication, what I think may be the appropriate standard to be applied here would be, I think, as the Attorney suggests, is a totality of the circumstances analysis.
But that may define the scope of information you may consider, but what is the standard?
Well, I think the standard, Your Honor, is I think can be determined by as identified in a number of cases where there are a number of different acts or events that can constitute a dedication. The case law has...
What does it mean to be dedicated?
We're trying to avoid the havoc that you talk about where we're to say deed only, and I guess what we're trying to tease out is if we were to say, Hanson, no good, your case good, where's the standard?
Well, I think Judge, you could look, first of all, in terms of dedication. As Mahajan says, not every 97 purpose is congruent with 97. But were you able to demonstrate that here is in Westfield, in terms of a standard, there's an ordinance that dedicates it to a park. A dedication could be here. The utilization of LWCF funds. I think those types of things, I think, would enable a standard to be established that you would be able to satisfy that for purposes of a dedication. And I guess my time's up, so I'll yield to my brother counsel.
To your brother.
Good morning, Mr. Chief Justice, and may it please the Court. Seth Schofield on behalf of the Commonwealth of Massachusetts. Let me begin by answering the question that was just under discussion. What should be the rule of law? The rule of law in this area should be, the test should be whether the government has unequivocally intended to set aside land for a specific public purpose. In this arena, park and conservation land, that is a particular Article 97 purpose. And I want to be clear that the court...
Let me stop you there. Page 41 of your brief. In each of these examples and many more like them, the Commonwealth has expressed a clear intent to designate in perpetuity certain lands for Article 97 purposes. Is in perpetuity part of your standard?
No, Your Honor. The effect of Well, let me be clear, Your Honor. The effect of the test is to designate the land for an Article 97 purpose in perpetuity, subject, of course, to the legislature's ultimate decision to determine that it might, in particular cases, be appropriate.
Of course, there's the possibility for the legislative override, but what do we do with your in perpetuity thing? Was that, did you misspeak, or do you mean something different in terms of measuring when it has unequivocally intended to set it aside?
Well, to be clear, Your Honor, I would not say that that is part of the specific test we are asking the court to reaffirm. And I do want to be clear that the court would not be adopting a new test. What we're asking the court to do is reaffirm a very old and longstanding test that has been the rule of law in this Commonwealth for over 100 years. There has never been a case, putting aside even Hansen, which I do want to address your question, Justice Gaziano, but there's never been a case that said a deed or other recorded restriction is required. In fact, these cases have long said that in the area of dedication and designation, a deed is not required. In fact, no writing is required at all. In regard to Hansen, Hansen is an outlier. It also does not need to be overruled.
Why is
It does not need to be overruled.
an outlier?
It's an outlier.
I disagree with it, but why is it an outlier?
It's an outlier because the facts are so unusual. It's a case of bad facts make bad law. But the critical fact in that case and how it fits within the longstanding common law rule of dedication, which is the gateway to Article 97 protection, is that in that case, the town did not perfect its intent to dedicate. That was a critical fact. And under our test, that would be equivocation on the question.
What actions in this case perfected the Article 97 rights?
That it was perfected originally when the town in 1948 placed the care and control of the land within either the Playground Commission, I think originally, and then later the Department of Parks and Recreation. The later City of Westfield's actions confirmed that designation. The ordinance in 1959 specifically uses the word designation or designated. It says heretofore designated as a playground in a park. Later, they accepted funds that come with them federal.
Hanson, there was a town meeting vote.
Yes, Your Honor. It was an unperfected vote, though. The vote was to, by deed or deeds, reserve for conservation, accept a deed or deeds for purposes of conservation. There is no evidence that in that case that a deed ever was recorded or even drafted. Also in Hansen, which is important, Hansen also indicates, as we've suggested in our brief, that the placement of land under the care and control of a conservation purposed department is also sufficient. The court cited Harris for that proposition. So Hansen is unusual, interesting, but there are facts in that case that make it distinguishable and also make it fit within the test that we are proposing.
So help me to sort this out, okay? And let's assume the town takes, as a tax taking of a farm. So now the town owns a farm. Town meeting discusses it and says, we don't quite know what to do with this, but for the time being, we'll treat it as a conservation area. And you, the Conservation Commission, are going to be responsible for its management. Is that the perfection of an intent to dedicate it, or is that simply a town saying this is what we're going to use it for the indefinite future until we figure out a better use for it?
If the town did not express any conditions or caveats as to the intended designation, then yes, it would be designated for an Article 97 purpose. We've cited as an example of a case where it's an out-of-state court case, a New York Court of Appeals case, Glick, where the question was whether the municipality had unequivocally intended to dedicate the land to a park purpose. There, the court, and I think this court would find the same, that there was evidence in the record that suggested the city of New York intended the park use only to be temporary. And so that would be equivocation on the unequivocal intent to dedicate. I do want to be absolutely clear that this is not a new test. This is a test, a rule of law that's been in place for hundreds of years. It's common in Massachusetts. It's common across the country, as you can see from the cases cited in our brief. And a contrary rule, a recording-only rule, would do immeasurable damage to Article 97.
I guess I'm trying to figure out, do you think Hansen and, Justice Milkey says in his concurring opinion, specifically Hansen and Mahajan, taken together, appear to say that the only circumstance under which such land will be considered subject to Article 97 is where the restricted use has been recorded on the deed. Do you think he's right in that, in saying that that's what the two cases taken together?
No, Your Honor, and I'm not sure that Justice Milkey thought that he was correct. That's why he indicated that he used the language appear to say, which is that he also suggests he had some ambivalence on the reading of Mahajan. Mahajan it does not need to be overruled. It very clearly sets out at least 3 ways in which land can be dedicated to an Article 97 purpose. 1, by deed. That would be an express dedication. 2, by placement of the land under the care and control of the Conservation Commission. That's Toro that the court cited. Then the court later went on to indicate that even use in certain circumstances, could be sufficient to designate land for an Article 97 purpose. So Mahajan fits also into the existing, longstanding common law rules of dedication. Article 97, to be clear, there's no evidence that Article 97 was intended to reduce protection for park and conservation land. In fact, Article 97 increased the common law protection for park and conservation land by changing the common law simple majority rule vote to an on-the-record supermajority vote, and then placed the requirement in the Constitution. Now, the Article 97 made no other changes to the common law, and therefore the prior common law cases that govern when land is dedicated for a particular public use should govern the inquiry today.
But Judge Milkey, in his dissent, as I understood it, is looking for a change in the constitutional interpretation, but that it was his view that you needed a recorded instrument in order to have the protections of Article 97. So if that's correct, you think that the majority opinion and the dissent's wrong as it relates to the requirements of Article 97?
Absolutely, Your Honor. We believe that both the majority and concurring opinions misread Mahajan. We do not believe that this court has to overrule Mahajan to reaffirm the rule. All of the guideposts are laid out in Mahajan upon a close reading. Now, if this court chooses to overrule Mahajan for one reason or another, no tears will be shed by our office. But I do want to be clear that the court does not need to, and I believe that we have clearly mapped out the path in our brief to explain why that is the case.
Okay, thank you.
Thank you, Your Honors.
Mr. Wilson, good afternoon.
Good afternoon. May it please the court. My name is Anthony Wilson. I'm joined by Attorney John Leibel. We represent the city of Westfield. I'd like to start today just by framing the issue is that the court's decision to uphold the appeals court, or that upholding the appeals court's decision is basically maintaining the status quo, whereas overruling the court's decision and doing what the appellants have asked would to basically change the nature of the constitutional provision of Article 97, and in doing so create chaos relative to municipal ownership of property that could or could not be Article 97 property. Specifically, as it stands today, Article 97, as interpreted by the court and enacted by the legislature, has essentially two manners of coming into effect under a property. The first is the most obvious one, that when the municipality or really any government agency comes into possession of the parcel, that it's recorded on the deed or on the instrument or on something that is recorded in the registry of deeds that states the clear intention that this property is meant to be restricted.
What do we do, though, with all the property that's out there that didn't have it happen that way? There's nothing on a deed.
And
Like, let's say some of the examples, even in Boston Common, I don't know if that's true or not, but like, if it was not acquired for that a purpose, like an Article 97 kind of purpose.
Your Honor, and I think that's actually a good example to use, and it's actually addressed in Mahajan. This is not an area law. It's an area law that has to be teased out of the decisions, but it's an area of law that's specifically covered.
Well, let me ask you then, do you agree with Justice Milkey saying that you put those two cases together and this is what you get, that the deed restriction is the only way you can do it?
I don't believe so, Your Honor.
So you think that's incorrect?
I do.
Okay.
And the reason that it's incorrect is that in certain circumstances, Boston Commons being a prime example, our Commonwealth has existed well before the registration, right before the registry
Right, got it.
statute, and way before we've had our sort of current system of recording instruments and knowing the history of pieces of land. Specifically, Judge Milkey cites to the case of Lowell versus the city of Boston regarding the Boston Common. If you read that case, it's a case prior to the enactment of Article 97, and it's a case in which the court acknowledges that the history and ownership of Boston Commons, there aren't any documents. There's no registered document to look at to know specifically why the city acquired the document and why the city acquired the parcel and what it acquired it for. In those cases,
Let me ask you, if I were to go and do a registry search with regard to most of the areas that people understand to be parks or conservation areas, would I find there to be any recording which would reflect what you describe?
you may or you may not, Your Honor, but I believe that Mahajan answers that question, because when Mahajan talks about other ways of designating a property or determining, really, it's for the court to determine if a property is Article 97 property. In the instances where you cannot look at the documentary history of that property and know definitively what it was for, then you can look at the use. And in fact, one of the arguments that the BRA used in Mahajan was that because its charter was to develop property in the city of Boston, it could never acquire property for Article 97 purposes.
Let me get you back to where you started. What you told us was there are two ways to trigger Article 97. One was by deed, and the second is what you're talking about, the subsequent designation.
Well,
So if you could just answer my question, what would constitute the subsequent dedication as discussed in Mahajan?
the subsequent dedication, well, I apologize, Your Honor. I'm going to take a little while to answer your question. But when I said that there were two methods, I meant that there were two methods for the court to determine if a property was Article 97. Number one is you look at the deed. If there is no deed, if there is no documentary history, or if the deed is unclear as to the purpose of the acquisition, then the court can look at the use and the history of the property. Where there is a deed and where it is clear that this property was acquired for some reason other than Article 97, following Hansen, following Mahajan, following the language of the statute, the court then needs something else on the record, the recorded record, to prove that the town specifically intended and perfected the decision to make this Article 97 property.
But doesn't use and history of the property cut against you, because the use of this property since 1946 was for a playground?
Your Honor, what I'm saying is that based on the facts of this case, the court cannot get to use, because we have a deed that clearly states why the town acquired the property.
The tax taking.
Correct. And therefore, you're not in the instance that you would be relative to a Boston Common.
But you're saying if it's a tax taking or taken for any other purpose, even if the town says, oh, this is land we want to be using for conservation, and we say this is to be conservation land under the direction of the Conservation Commission, that's not enough. There has to be some deed, the town has to transfer it to whom? It's still the town's property.
Well, I don't mean to say that there specifically has to be a deed. Again, the court talks about this in Mahajan. There has to be some document. Again, in
What
Mahajan, we
document?
talked about the.
If the town wants to do what you describe, and it says, we want the Conservation Commission to operate this land as conservation land, what does it register? What document does it put into the Registry of Deeds?
Theoretically, could register its order, its decision. It theoretically could redeed or as municipalities do, deed the land from. I'm thinking in specific instances of the school department to the Conservation Commission. But it would be something on the record because, as the court noted in Hansen, a contrary rule would undermine the very nature of the recording document.
So you want us to strictly construe Hanson, essentially?
In cases where you already have a deed, where the
Right.
purpose of the property is known and would be known to the court and to any future purchaser or owner of the property.
So you're saying that to show that there's a contravening purpose or an alternate purpose other than the purpose for which it was acquired, you need to have the deed,
Correct, Your Honor.
the recordation?
Correct. In the cases where there is a recordation, that anyone reviewing the record would see that this land was acquired for something other than Article 97
No,
purposes.
you argue that we're gonna wreak havoc with land use, and they argue we're gonna wreak havoc with land use. Who's right?
We're right.
Because I'm trying to look at this and trying to say, what are the rules going to be, and going forward, what's the city of town to do with all the public land they got by bequest, they got through all sorts of things that happened well before
And what-
Article 97 was passed.
And what I would say to the court, Your Honor, is that what we are stating is the current state of the law, and there is no havoc being wrought. Their rule, which would be that anything that the city does, anything that the state does, the brief of the Attorney General's office is actually very interesting because they attach three different agreements that don't specifically, in either one of them, sort of state the conservation purpose for the property that they are purported to be about. But we're not just talking about ordinances. We're not just talking about city council orders. We're not just talking about statutes passed by the legislature. We're talking their argument and their rule of law would cover sort of agreements between departments, any numerous type of agreement, any type of document, official document that you can find, maybe even a mayor making a proclamation on this piece of property on some specific day to honor so-and-so who played ball in this unused lot one day could potentially make this property Article 97 land. For those reasons, how could I or how could any lawyer advise their client, a municipality, to accept grant funding, to do any particular maintenance on the property, to do anything like that for fear that the land would inadvertently become Article 97 property?
What do we do with the fact that Westfield did accept quite a bit of money from the federal government as part of the Federal Land and Water Conservation Fund Act for the development of a playground in which it committed? It said, okay, we'll take this money to build a playground, and we promise you that it will continue to be a playground unless we get your permission to use it for some other purpose. What do we do with that?
What I would say is that particular issue first of all, is not really in front of the court. It's not really consideration under our understanding of Article 97. However,
isn't that a commitment by the town to use that land as a playground in something akin to perpetuity? Because we are taking this money for a playground, and the feds don't want to give you the money for a playground if 3 years later you're going to tear it up and put a parking lot on it.
well, two issues on that. One is that, it may, either through inadvertence or some other reason, it may put the town of Westfield in a not so popular light before the federal government. But in the process, sticking to the facts, in the process of this case, they were in the process of receiving approval from the federal government to do what actually is covered under the agreement, which is to designate other equal in sized land in another part of Westfield for the same purposes. So had this particular transaction not turned into this lawsuit, there would have been the same amount of, I'm going to use the term open space, in the city of Westfield, but pursuant to their to their grant. And I would think that the individuals who are concerned with conservation would encourage that type of activity by a city or town, rather than having the city or town first ask themselves the question, do I want to bound my hands and bound the hands of future decision makers, and take that really extraordinary leap of designating the property as Article 97 versus doing something that I know will improve my community and will further these open space goals in the near term.
Can I go back to your, the rule that you set up? Now, this land was taken for non-payment of taxes, right?
Correct.
But isn't there a difference between the reason that the land's taken and its subsequent use? Do you see what I'm saying? So it's taken for the non-payment of taxes. Okay, so now we have it. So that doesn't have anything to do with what I decide to do with this land. So, I mean, why does that matter, that it says in the deed that it was taken for non-payment of taxes?
I'll give you a short answer and then a somewhat longer answer. So the short answer is it matters because Article 97 basically makes it matter. Because if it had said something relative to those conservation purposes in the deed when they took it, that would have evidenced their intent, where we can't sort of go back and question the tax collector at the time or the city council at the time, why did you take this property? We know that it wasn't for Article 97 purposes at that time. My longer answer is that I would just point out to the court that we're talking about that a contrary rule actually is detrimental to the communities in the Western Massachusetts. We are not Boston, we're not Eastern Massachusetts. Land does not get snapped up and used in a second. Oftentimes, communities in Western Mass will take a piece of property and there will be no interest in developing it. There will be no interest in using it for anything else. So it sits, not generating taxes for the community, not doing anything else. That does not mean that it may not in the future be useful, but it sits for a number of years. In that time period, we want these communities to be able to use these pieces of property for something. And they should have the flexibility to make that decision. Should it be, if it's near a school, should it be a playground? If whatever it may be.
Well,
A contrary rule about use.
That's a completely reasonable point, but I don't know that the Attorney General's test is necessarily going to, in order to the detriment of some town that has that situation, because their rule would be the government has unequivocally set aside the land for an Article 97 purpose. Unequivocally is a strong word, the word they chose. So your problem is a serious problem, but I'm not sure that their test doesn't solve it.
Your Honor, their test really, I wrote it down. The rule of law should be whether the government has unequivocally expressed an intention to designate this property as Article 97 property. The problem with that test is, the problem related to what the city has stated is that their test actually is just a case-by-case analysis. What this court, by adopting that test, what this court would be doing is taking away certainty, because we have to go back and determine, in spite of contrary evidence that has been registered with the Registry of Deeds, in spite of contrary evidence, we're going to pull whatever documents we can find that were generated by that city or town, and come to court and say, no, don't build that school. No, don't build that new municipal complex. No, don't build whatever it is that the city or town wants to build or do with it, what the city or town is going to do with it, even though I can look at the deed or whatever is registered and know why they acquired it. I'm going to say that they've got something else, and I'm going to prove to you that this piece of paper, any number of, that could be written in any number of different ways, in any number of different formats, means that even though they acquired it for that, they really want to put this restriction on it. Lower courts would be inundated with these types of lawsuits, sort of based on the rule as articulated by the AG's office. It does not provide the certainty that the current status or that the relationship that Mahajan, Hansen, and Article 97 currently allow.
What if the rule were unequivocally set aside at the time it's obtained for Article 97 purpose?
I believe that currently is the rule. That would
No,
be.
that's not recorded.
Well, I guess let me sort of.
I guess your answer is they should record it then, right?
Well, I would say so. If you look at Hansen,
Right.
if you look at Mahajan, one of the BRA's arguments was that they have a general mandate to acquire property for development, and they said to this court that because of that, we can never acquire land for Article 97 purposes. The court came back and said, citing to the Attorney General's opinion, that in cases where the deed might be unclear as to the real purpose of your taking, then we will look at the use. But where the deed is clear, you know, there's no need to go that route.
So if you obtain a tax taking or tax, and you take the property and you say, we want this to be conservation land, and you put something in the recording to say this is our intent, and then a new selectmen come in and say, no, we don't. We want to basically undo that recording. Once it's undone, are you outside of Article 97, or once you record, are you forever in Article 97?
Once the recording has been made, you have to go to the legislature to get the 2/3 vote.
So once you record, it is forever.
Correct.
Okay, thank you.
Thank you, Your Honor.
All right.